Good afternoon and welcome to the first in our 2025-2026 series of Planning Live webinars. My name is Victoria Lane and I am a Senior Associate in the Brody's planning team. I am delighted to be joined this afternoon by Neil Collar, one of our planning partners, and Michael Hyde, a chartered town planner with over 30 years' experience working in the planning industry across all sectors, development management, planning policy, but with a particular emphasis and self-professed passion for planning enforcement, which of course is the discussion topic for this afternoon. Now, in terms of our discussion, enforcement is a session that we have had in mind for a while for Planning Live, and our guest today, Michael Hyde, is undoubtedly the person to take on this often thorny and invariably technical topic, not least because of his self-professed passion that I mentioned earlier. Michael began his career in local government, spending time working in all aspects of the planning system, but most prominently in enforcement. After 20 years as a planning officer, Michael has gone on to work in the private sector as well as for two national park authorities, spending time as a planning service improvement officer and in roles both north and south of the border. Drawing on such varied experience, he now runs his own consultancy, providing planning advice and training programs, including on enforcement action. And in this sense, he is both a skilled batsman and bowler, with a client base spanning planning authorities and various operators in the development industry. And with that, I'm conscious we've got a lot to get through. I'm going to hand over to Neil and Michael to kick off today's discussion. Thank you.
Thanks very much, Victoria, for the introduction, and welcome, Michael. The point of the discussion today is very much to look at practical insights rather than what the books say, because as ever, if you look at the legislation, if you look at the books, it's not really giving you the full picture. So I thought start by just where does planning enforcement fit within the planning system, as it were? And you've coined the description of enforcement being the most important leg of the planning stool, which is a fascinating way of putting it. Can you just explain what you mean by that?
I can, and I'm still taking all the credit for the three-legged planning stool, although it's so far back in the mists of time now, I might not actually have invented it. But if you go right back to the beginning when I started in planning, so 1990, give or take, as a planning assistant, when you started back then and you did your RTPI membership application, you had to show that you'd done a little bit of planning policy, a little bit of development control as it was then, and a little bit of enforcement. So I tried them all. I have to say, and with all due respect to my policy colleagues, I didn't get on with policy. I found it a bit dull, a little bit boring, very, very long timescales. But the bit that I really liked of the three was planning enforcement. And so when I was working for another authority, and for reasons we won't go into, they sacked the enforcement officer at the time. They were looking for one of the area planners to take on the enforcement role. And I was the one that took it on because I thought, well, actually, enforcement is great fun. And then what I did was I thought, well, I better get a book on enforcement now to see how it all works. And I've got a copy of it here. And I think if I hold it up, you can probably see it. So it goes a bit kind of weird on these background screens, but it's called The Effective Enforcement of Planning Controls. It's by a chap called Denzel Millichap. This copy I got for £1 on eBay. It's from some old planning library somewhere because it's still got a library card inside it. But I've got this quote that I've written down. So if I'm looking down, I just want to get this right, because what he said was forward planning cannot be a realistic activity unless development control decisions on the ground reflect the aspirations of the forward planning section. Development control is potentially an exercise in futility unless it can count on effective enforcement to deal with contraventions. And I kind of took this concept of the planning trinity that he came up with, and I refined it. I still, as I say, I'm going to take credit for this, into the three-legged planning stool. But the point I was trying to make, it doesn't matter which leg you take off the stool, it's going to fall over. And we used to talk about enforcement being the kind of Cinderella part of the planning service. And what I've been trying to do, I guess, ever since for the past 20 odd years is really just big up enforcement and make people understand how important it really is.
And again, thank you for coming on today to big it up, because I'm conscious that if you would describe yourself as an enforcement nerd, I would equally describe myself as an enforcement nerd, and that's probably Victoria's worst nightmare is two enforcement nerds on
the same seminar.
Yes, with a time limit. So moving on, because there is that time limit.
Of course.
Quite often the stories we see in the press are the big picture cases. And just randomly off the top of my head, there's the Crooked House pub in England, which was demolished, which is, I think, still the subject of continuing action. But maybe moving away from those high profile ones and just looking for a moment at the more bread and butter. What I've noticed is quite a lot of enforcement seems to involve what are probably just misunderstandings about when planning permission is required. Because if we stop for a moment and remind ourselves, the definition of development is what drives the need for planning permission. And even to planning people, it's not always easy to identify when planning permission is required. So, pity help the poor, normal person. But just thinking of examples come across, extending the back garden of a house because they bought some land in the next door field. In those sorts of situations, and going back to the experience that you had in enforcement, is that a situation where it's the negotiation skills of the enforcement officer that are important, just trying to see if there can be a positive outcome rather than leaving the homeowner in that scenario just feeling that they're hard done by because it wasn't their fault?
Yeah, absolutely. And there are genuinely so many misunderstandings. I did a bit of an analysis of our enforcement caseload once, and I reckoned that only about 1 in 10 of the investigations were begun because somebody did something deliberately. Most people do things because, as you say, they don't understand the planning legislation. They don't talk to the right people. I mean, I lost track of how many times I had to say to people, please don't take your planning advice from your builder. Please take it from us as the planning authority. And with the internet, it's even worse because there's so many people giving advice on everything, including planning, in dubious forums on the internet. It's hardly surprising that people get the wrong end of the stick and then just do things that should have had planning permission without it. And then, yeah, absolutely, as the enforcement officer, you've got to then try and find a way to resolve the situation. And most things, again, in my experience, can be sorted out. Retrospective applications or modifications or relocations or what have you. Yeah, every now and then there are things that are just so bad and so egregious, you have to take really, really firm enforcement action. But I always thought that it's the people skills that actually make a really good enforcement officer. I mean, now on my training courses, I'm training enforcement officers who come from every possible conceivable background you could think of. They're not all ex-policemen anymore, but you can teach people the technical knowledge, but if you haven't got the right personality to be an enforcement officer, so many that I've known in the past think they're Judge Dredd, and it's, well, I am the law. And it doesn't work. You can't throw the book at everybody. Some people you have to throw the book at them because that's the only way they'll understand. But most people you have to be nice to them because they didn't do it deliberately.
If I could just interrupt there, Michael, when you're talking about throwing books at people, we've actually had a pertinent question which says as follows: Could you talk about the practicalities of a planning authority actually taking down a shed or an extension? There seems to be a lot of leniency before a structure has to be taken down or change has to be reverted. Also, if a person refuses to apply for planning permission or retrospective permission is refused, at what point does the planning authority, and I quote, rock up at your door? And do they have a duty to give notice before showing up to demolish said structure?
Wow, there's a lot of
I know,
questions.
a lot in there.
There's a lot of questions in the one question. Yes, planning authorities can and do rock up and get things demolished, but the amount of steps that you have to go through to be able to get to that particular point, it's quite time consuming, which is why enforcement does sometimes, in the eyes of the public, drag on. The very first thing that you have to do is you have to ask yourself whether it's actually expedient to take enforcement action. Is it in the public interest to take action, having regard to your development plan, etc.? And if it's something that by and large complies with policy, you can invite a retrospective application. You might be able to sort it out. But if you would never approve that application in the month of Sundays, then you shouldn't be inviting it in the first place. You should just move towards taking enforcement action. You serve a notice, they appeal, on it goes. Hopefully the notice is upheld and the appeal's dismissed if you're on the local authority side. But then in Scotland, we're in a difficult position, and you'll know this as lawyers better than I do, because of our legal process and because we have to go via the Procurator Fiscal. Even though there's a criminal offence being committed if you don't comply with the notice, it's nigh on impossible to get a planning case into the courts for a prosecution. So that only really leaves you with the direct action option. So you have to go and get the money to do the works, to demolish the extension or whatever it is. And then the council has to keep their fingers crossed that they'll get the money back again at some point in time. And most councils that I work with just do not have a direct action budget. So it very rarely happens. So you end up being between a rock and a hard place almost if you really want to flex your muscles a little bit as a local planning authority, because you find your hands are tied.
And on the point about direct action, the thing that I came across is it's one thing to have the powers, but it's another thing when you actually look at the work that is required to be done. Because back in the day, when there was a fashion for having houses clad, and I remember a local authority talking about possible enforcement action and then realizing the legal liabilities of removing cladding from someone's house if something didn't go right. Just a minefield. So going into someone's garden and demolishing a shed, reasonably straightforward. Messing around with something they've done to their house, that's a whole different kettle of fish.
And you open up other issues to do with the Human Rights Act and the equalities legislation and all sorts of things, depending on the nature of the direct action. I mean, if there was a really big case down in England called Dale Farm, where they were evicting travellers from a site. Now, I can't remember how many millions of pounds that cost Basildon for a council, but they will probably never see that money again. And that involved, hundreds of people, police, there were film crews there. It was a phenomenal, just a logistical exercise just to actually do what they wanted to do. But they were so far down the road of taking enforcement action, they just couldn't be seen to pull back at the last hurdle.
And moving to a different example, we started out there talking about the example of extending back gardens and people not realizing, you might need planning permission because it's a change of use. Another one that comes up frequently in enforcement cases is the sighting of caravans. And we don't necessarily need to get onto travelling people. No. That's a further dimension of it. But for people that haven't come across it before, it's the issue of the uncertainty about whether or not it is development and whether you class it as an operation or a change of use. And indeed, And this might amuse people who haven't come across it before, but there's also just the issue of what is a caravan? And there's probably a lot of the audience going, what? How hard can it be?
And I was so glad when I saw this come up on the list of potential questions, because for anybody who knows me, I have become a bit of a sad planning nerd when it comes to caravans and the Caravan Sites and Controller Development Act, which came out before even I was born in 1960. I even got a King Caravan t-shirt for my 60th birthday from a mate who knew of my interest, which I did secretly wear underneath my posh shirt at a public inquiry recently, which was all to do with the caravan. And thankfully we won. But you touched on this, the definition of development earlier on, and this is where you have to start. I mean, you have to start there with every investigation that you do as an enforcement officer, because if there's no development, there's no breach of planning control. And that definition has got two legs. It's got one leg which controls operations, so building, engineering, mining, other operations in, on, over, or under land. And then it's got a change of use leg, which only becomes relevant if there's a material change of use. And who knows what a material change of use is? You'll always helpfully be told it's a matter of fact and degree, which doesn't really mean anything most of the time. You've got to make a judgment call. And when the caravan legislation was written in the 60s, everybody knew what a caravan was like, because it was a little thing with wheels that you towed behind your Morris Minor. But caravans have evolved so much since then that the definition of caravan and building have almost merged into one. And if you're going to take enforcement action against, let's just call it a thing, because that's a nice neutral term, you've got to know what that thing is, because that will dictate what you put in your enforcement notice. Are you alleging that they've built a building without planning permission? Or are you alleging that the siting of that caravan has triggered a material change of use of land? And if you get it wrong, then you're going to come unstuck at appeal. And it has implications for all sorts of other things, like time limits, for example, because we've still got the 4 and the 10-year time limits in Scotland. They did away with the 4-year limit in England recently. So it will, when the transitional arrangements work their way through, become a bit more straightforward. But if you're looking at erecting a building, it might be covered by the 4-year time limit. If you're looking at siting a caravan, it might be governed by the 10-year time limit. So you've got to know what it is that you're looking at. It's the what is it question when you go out onto site for the first time.
Sorry, Neil, just on that, we've had a very brief point on that just links directly. Another caravan nerd is asking whether you're aware of any way to enforce the simple siting of a caravan on land, assuming it isn't occupied and therefore triggering the 10-year rule?
Well, no, there isn't, because siting a caravan per se is not development. You've got to know why the caravan has been sited. Siting itself, if you just put as the allegation in an enforcement notice, and I've seen this happen before, and the notices have always been quashed. If you just put the siting of a caravan, it doesn't really say what the breach of planning control is. If the caravan's being occupied, then the breach of planning control is essentially the change of use of land to residential and the siting of a caravan. You could be storing caravans on land, and that could be a material change of use, but just siting per se doesn't really mean anything in a planning sense.
And that's a good example of the point you were making a few minutes ago about having to think, what is the breach? Mm-hmm. And being aware that there are potentially different ways of describing it, some of which, yes, takes you into a successful enforcement notice, and others of which, as you're saying, lead to an appeal being successful because actually the reporter in Scotland inspected in England saying, but it's not a breach of planning control.
Or you got the allegation wrong. So when I'm drafting, if I've got my local authority hat on and I have a kind of template expediency report that I'm writing out to justify why enforcement action is necessary, the way that report is structured effectively runs through all the potential grounds of appeal against the notice. And a ground B appeal is that what you've alleged hasn't occurred as a matter of fact. And so if you've alleged that they've erected a building, but actually what they've done is cited a caravan, then you're going to come unstuck. So just quickly going back to the public inquiry I did, again, this was with my local planning authority hat on, and it was down in England. But the whole public inquiry was founded on a ground B appeal because it all came down to whether the thing was a caravan or a building. We said it was a caravan, and they said it was a building that was immune from enforcement actions. The only thing that was determined through the inquiry was what this thing was, and it was a caravan. So we were fine.
I think if the audience were in any doubt about how complicated this is, they've now had a powerful example of it takes a lot of thought and brain power. Staying with the definition of development, because in a way, I suppose that was the point you were making. That's just the cornerstone of enforcement. That's what we'll always come back to. And thinking about change of use and thinking about the planning unit, I blogged about the recent Acnabobian appeal decisions, which were quite interesting in terms of complicated issues around what does a planning unit mean? How do you identify it? And I know you were involved in that with the local authority. I'm aware that the reporter's decision is now the subject of an appeal to the Court of Session. So we'll not talk about the reporter's decision, but maybe if you can just talk us round what the issues were there, because it's a very different circumstance to the ones we've been talking about, perhaps a little more unusual, but partly depending on the type of area of the particular planning authority. But it's coming back to, I suppose, that theme that I started with about misunderstandings of the planning system and individuals ending up with unfortunate engagement with the planning system because they didn't ask the questions at the beginning and now find themselves in a very awkward set of circumstances.
And it was a challenging one, and it was a really interesting one to be involved with, because it does take you right back to first principles again when you're thinking about how to draft and defend an enforcement notice. So this was a big area of land that had been split off into individual plots. They were being sold off for not vast amounts of money, so people were not risking a lot to buy them, £5,000, £6,000, £7,000, something like that, to buy a little bit of countryside in the Highlands. There were tracks and hard standings being put in. Some of the plots had then we'll call them things again, put on them. There were huts and pods and caravans starting to appear on the plots. And we knew there was a breach of planning control. We knew it was expedient to do something about it because, for no other reason, that it was in the middle of a site of special scientific interest. I mean, there were other planning issues as well. But because what we knew that we were fundamentally talking about was a material change of use of land, we had to define the planning units first. And there were two different ways we could have looked at it. Was the whole site one single planning unit, or did we have umpteen tiny little planning units, each single plot being a separate planning unit? And we, as you always do, fell back on tried and tested case law. There's a case called Birdle that helps you define the basis of a planning unit. We decided there wasn't enough physical and functional separation of each of these individual plots that they would reasonably be their own separate planning unit. So we just served one notice in respect of the whole site, but we served it on 85 different people because they were all the people that came up on the land registry on the title searches. We also put 14 more notices on the site for the owner occupiers on the site to make sure that we captured anybody that we hadn't served. And of those 85 notices, there were 30 appeals. And the reporter spent a lot of time looking at the planning unit issue and decided, thankfully, that we'd got it right, that it wasn't possible to subdivide that site. You had to take a holistic view of what was going on. They were all being marketed through the same agency. There was one access track leading up to all the plots. And on that basis, it was a single planning unit. And then we just wrapped up the operational development, the tracks and the hard standings in the allegation that related to the change of use, because they were only there to facilitate the use of all these little leisure plots. So yeah, 30 separate appeal decisions, one in respect of each appeal. And thankfully every appeal was dismissed and all of the notices were upheld. And as you say, there's the Quarter Session to face next.
And it's interesting again, just in looking there at enforcement officer workload, as it were, and the concept of the planning unit, as you were touching on there being options, case law to consider.
Mm-hmm.
So it's another example of it's not necessarily straightforward, and people listening might be thinking, gosh, one enforcement notice for 80 something different ownerships. But as you've described, the case law does provide that opportunity. The reporter upheld that approach, and we'll all wait for the Court of Session, depending on how things go, decision at some point next year, presumably, and be interesting to read what they have to say about planning unit. But I'm sure, again, it will show it's complicated, which should almost be the theme of the chat today. We've touched a couple of times in passing about differences between England and Scotland in terms of the procedures, the statutory requirements. A big one is in Scotland, they took away the ability to appeal against an enforcement notice on the grounds that planning permission should be granted. And I think, is that the ground A?
It is ground A. It's the team's planning permission. That's right.
Yes. It's still a thing in England. So you can do a ground A appeal in England and wrap everything up into the same appeal. So just interested because from what you've said, you operate within both jurisdictions. Do you see the situation in Scotland not being able to appeal on the basis that planning permission should be granted? Do you see that as a major drawback in practice?
No, I actually think the Scottish Government got it right. I mean, this is just my personal view, so I accept that people might not agree with me, but it seemed wrong somehow that you could almost get a planning permission through the back door by appealing against an enforcement notice. Because if you put in a planning application to get your planning permission, then it's got to go on the planning register. There's got to be consultations and notifications, and you have to assess it all properly in the public domain. So everybody knows what's going on. It's all very open and transparent. Whereas if you simply snuck in a ground A appeal on the back of an enforcement notice, you could end up getting a planning permission without anybody realizing that the planning permission had even been granted. It was just all a little bit behind closed doors. And I think just taking away the ground A right of appeal in Scotland was quite a bold move, but I think it has actually made things a lot more straightforward. If you want to get planning permission for something, you now have to apply for planning permission for something. Now, contrast that in England, where they still have their ground A right of appeals. they've now made it more and more and more complicated that even the planning inspectorate don't know how to work things out a lot of the time. Because in the old way, you could have two bites of the same cherry. You could put in a retrospective application, have it refused, appeal the refusal, then the council served an enforcement notice, and then you could lodge a ground A appeal and try and get it the second time around with a different inspector. And they thought, oh, no, that can't be right. We better limit it so they can only have one bite of the cherry. Now they've just changed it all again under what's called the Levelling Up and Regeneration Act, LURA, in England. They've now tried to push you towards only being able to appeal against the retrospective refusal and then denying you a ground A right of appeal. But even with a flow chart that one of my colleagues that works in England drew up for me recently, I still can't fathom it out. And then another consultant told me recently that PINS had originally denied their ground A right of appeal when they'd lodged it, and then had come back to them and said, oh, no, actually, we've thought about it again and we got it wrong. And you have got a ground A right of appeal. So it was brutal in Scotland, but it's way more straightforward.
This is one that I've not discussed with you, but just interested if you've got a view. You mentioned a few minutes ago the change in the enforcement time limits. So in Scotland, we've still got 4 years for operational development, 10 years for change of use, breach of condition. But in England, it's all been standardized to just 10 years for everything. Do you have a view about whether that's a change that we should mirror in Scotland, or if the situation in Scotland is acceptable?
I can see the logic behind it, because you do get some, what on the face of it might seem to be quite odd decisions when it comes to time limits. Let's say you've built a house without planning permission, and you did it 6 years ago, and then you moved into it. The case law now, the prevailing case law, would indicate that the actual physical house, which has been there for more than 4 years, as an act of operational development, has become immune from enforcement action, so it can't be demolished. But you can still require the use of that house for residential purposes to cease, because that hasn't been going on for the 10 years. Because there is that other 4-year time limit, but that only relates to the change of use of a building to a single dwelling house. So if you just built a house, you didn't change the use of anything because you just built a house. So it led to some kind of slightly odd situations where buildings have become lawful but uses hadn't. So it has tidied it up a little bit. But then 10 years is quite a long time to have to be able to get away with something now before it becomes immune. Now, I think when I was doing a bit of research, and I think in Northern Ireland, it's either 5 or 6 years for everything. It's always been one time limit, and it was more than 4 and less than 10. I think it's 5, but it might be 6. But they just brought the time limits down a little bit, because 10 years to gain immunity for everything is quite a long period. I mean, that benefits the authorities, obviously, because they've got longer to take enforcement action. And I suppose my heart is still with the local authorities, so maybe I should say it's fine.
Another thing that I wanted to touch on, and again, it's looking at changes through the years. When the enforcement regime in Scotland was reformed, and I can't now remember when that was, long enough ago that it doesn't matter in a way. One of the reforms was to give the appeal reporter wide-ranging powers to correct flaws in the enforcement notice. And before then, it was really any mistake in drafting at all. The appeal would be successful. The authority would have to go back to the drawing board, start again. Given, as we've just been talking about, the fact that there's quite a lot of time within the time limit, there would always tend to be time for them to have another go.
Yeah.
So not necessarily efficient in the round. So yes, reporters now have wide-ranging powers, and really wondering in your experience to what extent those powers are exercised, and has it really reached the stage where it's a bit of a get out of jail free card for councils?
Yeah, I suppose the answer does depend on which side of the fence you're on. So when we're talking about drafting enforcement notices, we always refer to another little bit case law, Mill and Mead, and we talk about this Mill and Mead test. And that's basically that anybody who receives an enforcement notice must be able to say that within the four corners of that notice, they can see what they've done wrong and what they've got to do to put it right. And also when they've got to do it by. But if the notice doesn't contain everything that they need to know, then it's going to get quashed. It's going to be a nullity. So a notice that's a nullity, it never existed at all. It's so much waste paper, as the courts expressed it. And I heard from somebody down in England at Pins that about 1 in 25 enforcement notices are determined to be a nullity. Now, if it never existed, it can't be corrected. And so things get quashed as a nullity for really, really basic reasons. I had one quashed quite a few years ago now, but for a simple reason. When it came to the period of compliance for an unauthorised use to stop, the local planning authority put immediately. Now, immediately, there's case law out there that had they known about it, they would have realised you cannot put immediately as a period for compliance because it's not a period of time. Put a day if you want to, or a week or a month or whatever. So that notice was just an automatic nullity. Another really common mistake is requiring people to submit things for further subsequent approval as a step on an enforcement notice. You just can't do that. It's such a basic error, but it still happens all the time. If a notice isn't a nullity, then the point that you're making is that since the Act got tweaked a little bit, it now says that the reporters can make any variation or correction to a notice as long as it doesn't cause prejudice to either the appellant or the planning authority. And it's a massively broad power. Certainly one of my appeals that the appeal was dismissed and the notice was upheld, I was bitterly aggrieved at that. And I showed the decision to a former inspector from Pins down in England that I know reasonably well. And his comments were that he thought that the reporter bent over backwards whilst skating on thin ice to correct the notice and help the planning authority out of a hole. So I think I was right to be disappointed when we didn't win that one. But any notice, if it's not a nullity, then, within the grounds of not causing prejudice, then the reporters can do whatever they think is reasonable to try and knock them into shape.
Michael, I'm conscious of time. We've got another question that just touches on an aspect that we haven't discussed this afternoon, so I'm keen to squeeze it in if we can.
Yeah.
So this question raises issues about breach of condition notices.
Right.
And this person had an example where officers served a notice in relation to a condition which required the development to be carried out in accordance with the drawings.
Mm-hmm.
So they served the notice as a means to secure the completion of steps that the developer no longer wished to install. So despite setting out why they were wrong in being served with a breach of condition notice, it was only when the developer pursued a judicial review that the planning authority actually backed down. And so this person's question is, do you think that there should be a mechanism to appeal a breach of condition notice, obviously brought in through legislative changes? Do you think that would be a useful, a sort of further useful aspect in the overall mechanics of enforcement type action?
Yeah, I'm not sure is the honest answer. I mean, when breach of condition notices came in, and they were one of the things that came out on the back of a report called the Carnwath Report in about 1991, 1992. Carnwath looked at the whole enforcement system and thought they could do with a few more notices. We got planning contravention notices and breach of condition notices and a few other things. And breach of condition notices were just there to tackle the really simple things. The condition said you should have painted your door blue and you painted it red. Paint it blue because that's what you should have done. No right of appeal. And if you didn't comply, prosecute them, which again, great in England. There is another mechanism for dealing with the more complicated breaches of conditions, and it's what we always tend to advise, and that's just a breach of condition enforcement notice. So it's an enforcement notice, but the allegation is that you've not complied with the condition, and that does open up a right of appeal to a reporter. So it then lets the reporter work it out and come to, hopefully a sensible conclusion. So I think BCNs are fine as they are, but they should only ever be used in relatively limited, straightforward circumstances where the breach is obvious and it can easily be remedied.
And as you say, it comes back to whoever's serving the notice having the requisite experience to be aware of the difference between a breach of condition notice and a breach of condition enforcement notice. As you're saying,
yeah, absolutely.
So, well, with that in mind, I am really conscious of time, and I know I was pushing my luck there with squeezing in a final question. But I think that final question really just highlights, Michael, your expertise, and so I must thank you for a really thorough run through the mechanics of enforcement action that I think a lot of us as practitioners can at times be a bit intimidated by, but certainly knowing that there are people such as yourself out there with the expertise to navigate the quirks that you have identified gives us all a real insight into how to handle it properly. So thank you very much for sharing your experiences and some war stories this afternoon.
You're welcome.
Thank you to Neil for leading our discussion as well. And just as a final plug, we of course are already now thinking about our next Planning Live session, which is due to take place on the 30th of October, 4 o'clock at the usual time on Zoom. And we'll be talking about compulsory purchase orders. So please do join us if you can, and look out for the details about that session that will be circulated in the next couple of weeks. So just thank you to Michael and Neil, and thank you to everyone for joining us on the podcast this afternoon. Thanks very much. Goodbye.
Thanks. Bye.